Thank you very much. Mr. Callan, Mr. Switell, before we start, we've looked at the papers. We hope, a keen appreciation of the issues, and 2 points arise in particular. First, there's a cross appeal. If the cross appeal is right, then the question of late service and the rights and obligations of a defendant in those circumstances, whatever, don't arise. So in any judgment that we would produce, that's obviously the point that we would address first. So that might indicate that we ought perhaps to hear from Mr. Switell on that point first. And then the second point is this: you will have received yesterday an authority from the court in the case of Robertson and Google. That was a case that the court heard at the very end of last term, and for various reasons it was only handed down yesterday. So we provided it to you as soon as we could. So it wasn't as if we kept it up our sleeves. I mean, I think you had it within 10 minutes of it being handed down. It's obviously potentially directly relevant to the appeal because it endorses various arguments that the appellant puts forward in this case, which on the face of it, therefore, is a second reason why we think it would be appropriate to hear from Mr. Switell first, because effectively on the key argument on the appeal, you would have to be able to distinguish Robertson and Google, because otherwise, I mean, it's a binding Court of Appeal decision. So for those two reasons, we concluded that it was going to be best to hear from Mr. Switell first. So, Mr. Switell, I'm sorry about that, but that's the way the cards fall, and I hope that's a fair explanation as to why we think that should be the case.
Absolutely, my lord. Yes, indeed.
So if you want to deal with the 2 points in that sequence, then that would be helpful to us. So can we start with the cross appeal, and then what you say about Robertson.
My lord, yes. Beginning with the cross appeal, if I can take you to the key passages in the first judgment of the learned judge in the core bundle. The first part is at paragraph 61 on page 88 in the core bundle. And
88?
Page 88, and it's technically paragraph 61, but 61 goes over the page and it's at Roman 1 at the top. And the central issue is this on the cross appeal. It's going to be attempted service by way of DX. And the question is going to be, was a step taken before 4 o'clock on a Friday afternoon, or was it not? And the facts are laid out very plainly by the judge in the two passages or 3 paragraphs I'll be taking the court to. And we can see in this Roman 1 that we have the documents being sent to Gateway Legal. That's the first defendants, the current defendants' lawyers at the time. They're going to be sent by DX, and the witness statement sets out the documents having been prepared for DX after 3:40 in the afternoon. My lordship would appreciate from the skeleton arguments in the witness statement it was a fairly high pressured Friday afternoon at that point. We're placed in
Well,
a
it had been
designated
allowed
area.
to become a high-pressured Friday afternoon.
Yes.
I mean, I can see that it was, but it had been allowed to become that.
Indeed.
Yeah.
And the documents were placed in a designated area of Edward Stufy Smash office reception for collection by the DX courier. And my lord may recall that when in some chambers, some law firms, one leaves out documents for collection by the DX person who comes round and picks up the correspondence for that method of correspondence. It says such usually occurring after office hours with the DX courier having a key to the office. So that is what's happened. And we go on to page 104, and this is the start of a section of the judgment which deals with service by DX on the first defendant. And in the first few paragraphs, a number of those issues have fallen away, such as, was it going to be the correct DX address? The core part starts at paragraph 111 and then goes into paragraph 112. The second question is whether such a sending occurred within time, being by 4 o'clock on the 21st of April 2023, that of course being the time prescribed in the order from November 2022. Here the evidence from Ms. Rana is that the claim form was left in the EDS reception by the DX courier, which took place on the usual basis after office hours, i.e. after 4 o'clock in the afternoon. That evidence has not been challenged, and I accept it and regard those matters as being proved and balanced probabilities. However, I note Ms. Rana does not identify precisely when the documents were printed and let out for collection, although it would have been after 3:40 in the afternoon. Paragraph 112. Nevertheless, even if the printing out, etc., took place before 4 o'clock, I do not regard that as sufficient for the relevant service step to have been taken in time under CPR Rule 7.5. We'll go on to look at what 7.5 says in a moment. The leaving of the material in the EDS reception cannot, in my judgment, amount to a delivering to the relevant service provider, and the collection by the relevant service provider only took place after the 4 p.m. time limit contained within the November order. Then Master Dagnall went on to consider the counterfactual, that whilst position might be different, although I reached no conclusion on the point, if material had been placed in a box owned by the DX provider, and possibly to which only the DX provider had a key, Rana only states the material was left in reception, and that the DX courier had a key to the office enabling access after office hours. Therefore, in regard, there was sufficient service on first defendant. So I would characterise a key issue in this cross appeal as going to be the question of what does a claimant have to do to satisfy Rule 7.5. At this point, I intend to take you to the authorities bundle. My lord, because of Google and Robertson having been handed down yesterday, my learned friend very kindly produced an updated authorities bundle which included it in the electronic version.
Okay, don't worry. I've got Google and Robertson separately as a matter of paper. So
otherwise, I would take the court to the hard copy authorities bundle to look at these parts of the civil procedure rules. And it's in the second printed bundle,
yeah,
and it's behind tab 24. And the relevant rules at page 519 of the printed authorities bundle.
yeah.
And it's 7.51. Where the claim form is served within the jurisdiction, the claimant must complete the step required by the following table in relation to a particular method of service chosen before 12 midnight on the calendar day 4 months after the issue of the claim form. Now, I'm going to be focusing in due course on the phrase must complete the step required. But then we look at the first entry on the table underneath Rule 7.5, the method of service, and the entry includes first class post, document exchange, or other service which provides for delivery on the next business day. And the step required is posting, and I'm not placing any weight on the word posting, it's the other parts. Leaving with, delivering to, or collection by the relevant service provider. So the question is, by leaving the DX correspondence, which included the claim form, out for collection for the DX provider in the solicitor's office after 3:40 in the afternoon, does that fall within completing the relevant step required, i.e. leaving with, delivering to, or collection by the relevant service provider? And as I've set out in my skeleton argument in respect of the cross appeal, which can be found at page 41 onwards in the core bundle. I, at paragraph 24, set out how this rule is, I'd say, relatively new. This was introduced in 2008, came into force on the 1st of October 2008. And the effect of this rule change, as is plain from the language, was to require the claimant to complete the step required. And I would submit the focus is on the claimant completing the step. And in due course, I'm going to be making a submission. The focus of the rule is not on the correspondence leaving the claimant's possession or going into the service provider's possession. The rule plainly focuses on completing the step. And paragraphs 29 to 31 of my skeleton argument, I've set out there has been some consideration of this rule, but so far as we can see, or I can see on the appellant side, the precise meaning of the DX point has not been considered. But I would emphasise what was said in the Paxton Jones against Chichester Harbour Conservancy case, decision of Master Dagnall, which in due course was upheld or proved in the Court of Appeal in Kennedy against National Trust for Scotland. And the purpose of the change was to try to ensure that claimants knew clearly what step to take and by when, so as to serve the claim form in time. So, to take some examples, if I take the correspondence, put it into the post box at 3:40 in the afternoon, that is the last step I can take, and that's the paradigm example for posting. It doesn't matter if the last post is gone, the next pickup is going to be on Monday morning.
That is because by putting it in the post box you will have posted it, and therefore that constitutes posting.
Yes, indeed.
But you want to conflate, don't you, leaving with and collection by. You say what you did was leave for collection.
Yes, indeed.
But that's not, there is no leave for collection isn't the step. It's leave with or collection by. And you're trying to collate those two and create a new step, which is leaving for collection.
And indeed, my lord, that's set out at paragraph 39 of my skeleton argument, my secondary point, as to the fact that you don't need to, I would submit you don't need to deal with these words disjunctively. It is possible to leave with for collection by the relevant service provider.
But each of the steps which are listed here result in the document effectively being in the possession of the service provider, whereas your step doesn't. It remains in your possession, your solicitor's possession, until it is collected.
The other method of service, and I put this in page 46 of the bundle, it's in my skeleton argument, is electronic method, is sending the email or other electronic transmission. I don't want to get into the nuts and bolts of what happens when one presses send. But the focus on that point is on sending the email. It isn't necessarily that going from one server to the next server and then from the defendant's server into their inbox. The focus there is on completing the step. And I would submit that the focus of all of these steps is not on relinquishing possession, particularly in possession of the service provider. The focus is simply on what do you need to do. So, for example, if we take the master's hypothetical situation, there is a locked box in the solicitor's office that only the DX provider has the key to, has access to. I put it in the box, and therefore I would say the focus is on my completing that last step. It isn't on my leaving or losing possession of it.
Well, that might be a difficult case, but that's not the case here.
No.
Also, it might be said that that was the method of delivering it to them. That might constitute delivery. You see, I have a little difficulty with your analysis, simply because you say that the focus is on a step to be taken by the claimant. I don't see how that fits with the words collection by, because collection by has nothing to do with the claimant, it has to do with the service provider. That's something they've got to do. They have to collect it.
Yes, indeed. And those last two words, collection by, provide less support for my submission than the words leaving with.
Right.
If I've made an arrangement with the DX provider, the way we shall carry out DX is by my leaving it somewhere, and that's in this place, it's leaving it in a place for the DX to collect it. That is the arrangement I have made with the DX provider.
But it's not with them. That's the problem. You've got to give some meaning to the word with. So leave, if just in a matter of ordinary English, if I leave something with somebody, the other person has it in their possession because I have left it with them. And if it's staying in my solicitor's office, it's not with somebody else, it's with my solicitor.
If I have, say, a set of pigeonholes, and I say, and someone wants to give me a letter, I could say leave it in my pigeonhole, and that would be leaving with me or delivering to or collection. That would fall naturally. But if I was to say to that person, leave it in your pigeonhole, that's where I'll find it. If that is the arrangement I've made, I would submit that is leaving it with me, because I will then be able to go and pick it up, which is essentially what I've asked the DX person to do, which is to come in and they will collect it from that certain point. So this does
the key element of this. When it's been left out on the shelf to be collected in the solicitor's offices, the point is that they could subsequently change their mind and decide actually they'll take it away from there and not send it. And the point about all these three is that these are all irrevocable steps, aren't they? You post it, you leave it with, or you deliver or it's collected by. But your method isn't irrevocable. Somebody could come along and say, oh, actually, we've made a mistake in that document. I'll take it back and take it back down to my office and redo it. Leaving it in your office so that it will be collected later, that's subject to it not being taken back again.
And I would accept that most of these steps, or the steps required at first blush in the box, do appear to be irrevocable. So, for example, delivery document to leaving at the relevant place, the step required delivering to or leaving the document at the relevant place. But say, first of all, if I have left a document at the relevant place, that is the very last step I can take, and that's what the language of Rule 7.5 refers to. Secondly, there's nothing to stop me taking it away again, and there are some classic postal services cases where the person sending the letter takes it away again. So I would suggest, and it's my essentially the whole part of my submission, that Rule 7.5 looks at what is the solicitor, the claimant, to actually do. And if on that Friday afternoon, what they had to do was leave it out for the DX person to come and collect it. If they didn't come that Friday evening, for whatever reason, in the same way as the postman doesn't come to collect the post box, doesn't mean I haven't taken a relevant step. And I would suggest that effectively that would be an unfair distinction. Because my arrangement with the DX provider is, I leave it out in that place, they come and collect it. In the same way as my understanding of a post is, I put it into a post box, the post box is emptied by the postman. So if a DX person doesn't come on a Friday evening, doesn't collect it, doesn't mean I haven't taken the relevant step.
But does that mean that you've served it? Say there was a cataclysmic snowstorm and nothing moved for a week, and the paper still sat on the receptionist's desk.
But I would say yes, it still counts as service, in the same way as the post box doesn't get emptied during that week, because the arrangement I have made with the DX provider is that I shall provide my correspondence with the DX provider by leaving it in that place for them.
But this is all in relation to 7.5.
Yes.
But here there was a court order. The court order was that the claimants had to file and serve the claim form and particulars of claim by 4 p.m. on the 21st of April.
Yes.
Firstly, was the claim form and particulars of claim filed by 4 p.m. on that date? I mean, that must mean filed with the court. The answer must be no, mustn't it?
I don't know if any focus was paid to that.
Well, that may be, but let's just take it in stages.
Yeah.
That since they were printing off the documents at 3:45 in the office, and your case is that they were left on the receptionist's desk at some point, and that's leaving with, it doesn't look as if anything was filed with the court, does it? I mean, perhaps at some point you should take instructions on that, but at the moment, it looks to me that that part of the order wasn't complied with. And then served by that time, on that date. All of the arguments about leaving with, even assuming that you're right, shouldn't all this have been done the day before? Because the reason that first class post and DX are proper service is because it's delivery on the next business day. So if you had to do something by 4 p.m. on the 21st of April, and you say, well, first class posting is all right, or DX is all right because they deliver the following day, wouldn't you have needed to have done all this on the 20th of April so as to ensure you complied with the court order?
I would suspect no, because of the fact the court order was agreed, it was a consent order, and then made in the backdrop of Rule 7.5 and should be interpreted as part of Rule 7.5.
Except that the words are very clear. You've got to do something by the 21st of April. In other words, that the other parties are entitled to have those documents by 4 p.m. It's filed with the court and the other parties have them.
Rule 7.5 only requires you to actually complete the step by a certain time for service to actually take
I know, that's the importance then of the court order, which doesn't get into any of these niceties. It's just a very simple order. You've got to do this by the 21st of April. And it's file and serve, which often go together because that means the documents are ready. And as my Lord says, it's an irrevocable step. They're filed with the court and they're served on the other parties.
Even if you posted it, it wouldn't be deemed served until the next business day. So it wouldn't have been served in accordance with the order. And the same must apply, surely, to DX or leaving it with the courier.
Now, this is a point which is touched upon in paragraph 90 of the judge's first judgment, at page 101 in the core bundle, where at paragraphs 90 to 92, the master notes what's common ground between the parties. The November order extended the time for taking the service step under 7.5 to 4 p.m. on the 21st of April 2023. So that was common ground between the parties.
But nobody's dealing with filing.
No one is dealing with, and no one, as I recall, would be correct, had taken a point about whether it had been filed in that time or not. But
I am, I'm afraid, because file and serve is a very simple. I mean, it couldn't be more straightforward. You file and you serve it. It's ready, and that's what you do. And so at the moment, you know, I think that if service by the DX was the right thing, then at the moment I can't see why this should not have all been done on the 20th, so that it was then all the ducks were in a row for the 21st.
The point, if I just take the point about filing and the distinction between that and service, and here we touch upon some of the points in the main appeal. Service is the core element of how the court assumes jurisdiction over a party, and the rules do make a clear distinction between service and other procedural steps. And if it had not been filed by 4 p.m. on the 21st of April 2023, then it was a breach of a November 2022 order. But no party appears to have taken a point in respect of that, and therefore under Rule 310, effectively the parties carry on regardless. And I'll submit the filing point is something which is not dealt with, for example, under Rule 7.6 in its own set of procedural rules. It would be dealt with under an application under possibly under Rule 3.9 if one can find an implied sanction, or alternatively just applying the overriding objective. And this was one of the points that was raised in the second judgment about particulars of claim.
I'm not sure it'd be 3.9 because it comes back to the commencement of originating proceedings, and the master was quite right to say that 3.9 is irrelevant and what matters is 7.6.
Yes,
I appreciate filing slightly different, but that is, the master was plainly right about that. Anyway, okay, so
what we have at paragraph 90 is what the focus, how it crystallised at first instance, which was the time for taking the service step under 7.5 to 4 o'clock on the 21st of April 2023, which might explain how our submissions on the cross appeal have become crystallised in that way, by looking at whether something was done before or after 4 o'clock on that Friday afternoon.
on that point, that's to say that before or after 4 o'clock, the judge, Master Dagnall, makes the point that there's no evidence as to when it was left out for collection. In other words, he can't say that it was, that the claimants haven't shown that it was before 4 p.m. That's right, isn't it? On the evidence.
Yes, that's at page. We can go back to paragraph 111 in the judgment. Page 105, and just it says the evidence from Varna, the claim for, was left in EDS reception for collection by the DX courier, which takes place on the usual basis after office hours. Evidence not being challenged. I note that Varna does not identify precisely when the documents were printed out and left for collection. So Master doesn't actually make a finding as to whether.
Well, he can't, because there's no evidence that it was left out before 4 p.m. It was sometime after 3:40.
Yes, that is the extent of the witness statement, and if needs be, we can go to the supplementary bundle. But yes, that.
Well, we don't need to go there. I mean, the point isn't an issue in the appeal, so this is the Master's assessment of that evidence.
Yes.
Yeah.
I mean, my learned friend raises this point in his skeleton argument as to whether on balance it happens before or after 4 o'clock. But I would invite the court to accept it was printed out after 3:40.
But you need to show it was printed out and left for collection before 4 p.m.
Yes.
And you can't.
There's no direct evidence of that. I'd invite the court to infer from the fact that service steps were being taken knowing there was a 4 o'clock cut-off, hence everything happening after 3:30 in the afternoon.
Well, the master is clear that he can't make that inference. He just says there's no evidence. So it's asking quite a bit for us, isn't it, to make an inference that the master didn't make?
Well, I'd suggest that the master doesn't need to deal with that because of his conclusion in paragraph 112. Even if the printing and etc. took place before 4 p.m, I do not regard that as sufficient. So,
well, there are 2 points in play. One is whether 7.5 means what you say it means.
yes,
That's the interpretation point, and you've dealt with that, and you've answered the questions of my lord and my lady. And the other is, even if you were right as to the interpretation, can you show on the facts that that's what you did?
no, I'd have to ask the court to draw an inference from the fact
Yeah.
that all these steps were taken in the knowledge there was a 4 o'clock cut-off for taking a step.
4 o'clock cut-off had been, I assume, within the knowledge of the solicitors for the previous 6 months.
Yes, and I can take the court to the first witness statement of Ms. Rana, but essentially there was a realisation on the 21st of April that what had been thought to have been agreed would actually have not reached the final agreement, and the master deals with that in part of the judgment.
Yeah, because there were all kinds of points taken that there was an agreement and so on,
Yes.
and one by one the master rejected each of those.
Indeed. So that, I cannot speak to whether objectively or reasonably that was right or wrong, but certainly it was not until the 21st of April that there was a realisation that a lot needed to be done by 4 o'clock in the afternoon. And it's against that. Sorry,
do we know what time the fax was sent?
I believe we do. I believe that is set out in the supplementary bundle because we have the fax attempt sheets. I believe they have. I think it's
Between 3:49 and 4:03.
Yes, that's at page 131 in the supplementary bundle. And I would suggest it's noteworthy, of course, that seems to be. I don't know if we. Yes, indeed. If we go to page 139.
139
of a supplementary bundle.
Well, if they were being faxed at 4:03, unless they printed out 2 sets, they couldn't have been left out for collection before 4, could they? Because they were being faxed 4:03.
I cannot recall whether the witness statement refers to how many sets were printed. I don't believe the witness statements do say how many sets were printed.
Sorry, what was the page in the supplementary bundle you took us to?
That was page 131.
131.
That's a summary of the fax attempts.
Right.
And because these points almost developed by an exchange of witness statements in the run-up to the November 2023 hearing, it's why we don't have almost a detailed point-by-point in a single witness statement as to what happened. Page...
One shouldn't need more than one witness statement, surely, setting out a timeline.
And the timeline would be that we initially relied upon as Ms. Rana's first witness statement. That's in the supplementary bundle starting at page 31. And this gives a flavour of what was happening on that Friday afternoon from paragraph 28 onwards, where paragraph 28, email sent on that day, gave a deadline of 2:45.
And this was all trying to get yet a further extension.
Yes.
So the focus wasn't on complying with the order, the focus was on trying to get yet a further extension.
Yes, and it's after 3:22 that the focus changes from getting extension to completing the service step.
Yeah.
And we can see that because at paragraph 33 we have the telephone call to Gately Legal about the fax number, trying to get a fax number for Gately Legal.
What's said at paragraph 34 is the receptionist at my firm attempted to fax the documents, not a copy of the documents. It seems to me that's the end of it, isn't it? If that's the evidence.
I mean, just to conclude on that point, the key passage is in the third witness statement to Ms. Rana at page 128, paragraph 6, which I think my lordship was really referred to.
Sorry,
128, paragraph 6 of Ms. Rana's third statement. Talks about my junior colleague sent an email instructing the receptionist to send a claim form, response back covering letter to Mayor Brown by fax and by DX.
Those are the instructions.
Yes. Then at paragraph 8, the same process was followed. So no, there is no direct evidence of that taking place before 4 o'clock. What I do, and from this analysis of the fact sheets, is I suggest the focus on there being a 4 o'clock time.
All right. Anything else on the cross appeal?
My Lord, no, you have my submissions on the cross appeal.
Thank you very much. All right, then the second point is the question of the decision in Robertson and Google, where we addressed the situation where a claimant failed to serve in time, raised the question of service with the court. The court didn't extend time, and so the question then becomes whether in those circumstances, in some way, notwithstanding the failures on the part of the claimant, the action could proceed against the defendant because the defendant had not issued its own Part 11 application. and we said that was wrong for the reasons that we set out in the judgment in Robertson. Those points, namely the acknowledgement of service and the Part 11 application, were front and centre in this case, because Master Dagnall, having decided that the claim form wasn't served in time and that the claimant wasn't entitled to an extension of time, then concluded that because there was no acknowledgement of service in Part 11 claim, notwithstanding the claimant's default, the claim could proceed. So on the face of it, Robertson and Google would indicate that the master was wrong. So I think we need to hear you as to why you say that wouldn't lead to the allowing of the appeal in this case.
I'm going to make two headline points. Firstly, I'm going to submit that in fact Robertson and Google does fit into the characterisation that the master gave of the different scenarios as to service and whether or not it's necessary to make a Part 11 application.
So you say it fits in
with the master's characterisation of the different scenarios. That, if I can take you to the second judgment, just to highlight where the master says what outlines that. That's in the core bundle, page 153. And paragraph 31 says there are three times the situation to be considered. 31, Roman 1, claim form validly served in time, defendant seeks out of time to challenge jurisdiction. That's not the scenario in the instant case, but it's one of the scenarios that identifies in the case law. Scenario 2, invalid service method used, no valid service method used thereafter. In that situation, no valid service at all. What has happened has simply been ineffective. The claim cannot proceed because service, unless a court otherwise orders, is the way in which a court takes jurisdiction over the defendant. I'm going to be submitting that Robertson falls into that category. And then the third scenario, appropriate service method used, but only out of time. And one of the points that the judge, at first instance, the master wrestled with was the lack of case law on this point. So I'm going to be saying that Robertson was a Roman 2 case on the master's characterisation.
because
And when I go through Robertson...
why is Robertson a category 2 case?
Because of the need to file and serve Form N510 or to get permission before attempting service. If you don't take those steps, it's invalid service.
Because they didn't serve it in time. If they'd taken those steps 2 months before, it would have been served in time.
But they didn't.
So that it was not served, it was not therefore served, in fact, at all.
Exactly.
But the argument was all about whether they were entitled to a retrospective extension of time.
Because they did ultimately serve.
Yeah, ultimately they filed the document, they got the document filed, whatever it is, N510.
Yeah.
So it was all about service out of time. It wasn't as if they used, I don't know, second-class post or that sort of type point.
And in due course, I want to go through Robertson just to make good my submission of Robertson.
But in any event, I just need to understand this. This all presupposes, whichever category this falls into of the master's categorizations, this all presupposes that we accept that these are fair or sensible characterizations.
And that would bring me on to my second headline point, which is how does one reconcile what is said in Robertson against Google with the Corro case. And on the face of Lord Justice Stuart Smith's judgment, Part 11 is the procedure to follow when you want to make a challenge.
But that's in a case where the points being taken about service and therefore jurisdiction were being taken by the defendant. It was the defendant in Corro who got the court to strike it out. In this case, as in Robertson, it was the claimants who were raising service. It was the claimants who were saying, we need a declaration that service was valid, or we need an extension of time. So service, and therefore jurisdiction, was front and centre before the court as a result of the claimant's applications, as it was in Google and Robertson. In those circumstances, what is the, just standing back from it, there's no purpose in having a Part 11 application. Everybody knew that service and therefore jurisdiction were in play because of the claimant's own applications.
Well, I can take the court through what the authorities say about...
I'm telling you what Google and Robertson says. So I understand, you say, how do you reconcile Robertson with Corro? I've just given you one fairly easy way in which it seems to me they're completely reconcilable. But you can make your submissions on that. But it seems to me that well, I'll let you develop your submissions in relation to that point. But I don't think, I mean, a submission that the particular of default, that's to say, we cocked up service, but it may matter precisely how we cocked it up. Was it method or was it time? I'm not sure that's a very fruitful area. The short point is service didn't happen as it should have done. I think that's the point. Otherwise, you get into the arguments, such as in Ideal Shopping, where the Chancellor pointed out that no good can come of fine distinctions between different kinds of default. So I see what the Master says about these various methods, but on the face of it, speaking for myself, I'm not sure that they really help the analysis.
Your own case, forgive me for interrupting, your own case makes that point very clearly, because your case is that you did service in time, and you did it by leaving it for collection. Now, if you're wrong about that, in terms of that leaving for collection isn't a valid method of service, then it was the wrong method of service, not out of time. Because you said you did it by 4 o'clock, but on this hypothesis, that was the wrong method, not out of time.
Well, I think if it wasn't the step wasn't taken by 4 o'clock, then it was actually collected by the DX. We know that because it arrived on the Monday morning. So it was actually collected by the DX. So it falls into. So if the cross appeal fails, I still fall into 7.51 and the box the steps I need to take out.
It's both, isn't it? That's the problem. That's the problem, is that in a lot of these cases, it's the wrong method in the first place, and then it's out of time. And on your case, once we get to this stage of the argument, it's both, because you used the wrong method because you thought that leaving it out for collection was service by 4 p.m. Wrong method. And then collection, which then happened after 4 p.m., was out of time.
Well, I
was 2 and 3.
It was the correct method, because as the Master found, from which there's been no appeal, it was permissible to use DX. And the question was, when was the step taken? And if the step was taken by the DX provider collecting it from the offices, albeit after 4 p.m., then that was a correct and permissible method of service for the purpose of Rule 7.5.
Forgive me, your argument for us today has been that you were aware of the 4 p.m. and that's why you left it out for collection before 4 p.m. That's your argument on ground one.
Yes, yes.
And that's the wrong method. If you're on this hypothesis, we're here because that's the wrong method.
It's a method permitted by the rules, albeit the step has been taken out of time.
No, forgive me. Your argument is we're not out of time because we used a particular method, leaving it out for collection. Now, on this hypothesis that we get to ground 2, you're wrong about that because we find against you that leaving it out for collection in your own offices isn't a valid method under 7.5. So we only get to this stage if you're wrong about that. So you are out of time because it is invalid because you use the wrong method. You're also out of time because then the second method was after 4 p.m.
So we know under rules, I think 6.3 of the CPR, that 6.31b, a claim form may be served by one of the methods being the document exchange, which provides for delivery on the next business day. Go to Practice Direction 6A, paragraph 3.1, how service is affected by post, alternative service provider, or DX. It says 3.1, service by post, DX, or other service provided for delivery on the next business day is affected by, and then 2, leaving the document with or delivering the document to a relevant service provider, or 3, having the document collected by the relevant service provider. So that is the valid method of service under Part 6, leaving to one side questions as to when it was actually done and the time provisions in Part 7.
So the only one that would work in this scenario is having it collected by, which was after 4.
Yes. And if it was collected at, say, after hours, let's say 6 o'clock, 7 o'clock in the evening, it was collected, and that is a valid method of serving within the jurisdiction under Part 6.
Well, it's like saying, well, we made various attempts at service before the deadline. We posted it the next day, and that's a valid method of service. And therefore, you can forget the fact that we made numerous attempts and got it wrong the day before. You've got a valid method of service, and therefore, you're into the Master's Category 3 instead of Category 2. You can ignore the bits that fall in Category 2. You just concentrate on Category 3, and there is a distinction between the two categories. That's really what it amounts to.
I absolutely agree. That is what it amounts to.
What's bothering me about it is why there should be a distinction between the two categories, because at the moment I can't for the life of me think why there should. But you're now going to help me. Yes.
Timing is crucial on service.
I mean, if you're right, you could just sort of ignore the time limit completely. I mean, not this case at all. Not this case, but hypothetically, somebody could say, well, I'll wait until after 4 o'clock, and then I'll put it in the post, and I can sit back and I can allow the whole of this case to carry on unless my opponent produces an application under Part 11 and seeks to argue that the jurisdiction, it should not be exercised or there's no jurisdiction. And that to me just is absurd.
Well, I want to come on to look at the point as to whether this is, to paraphrase my learned friend, a distinction without a difference. because I think that is one of the main parts of the appeal as to whether or not this is a distinction without a difference.
Well,
maybe I can start with what I intend to do then, to start with the Google and Robertson case. Because I agree, if I cannot distinguish Google and Robertson, then I'm in a more difficult situation than if I can distinguish Google and Robertson. I think that is fair to say.
Well, if you can't distinguish it, that's the end, isn't it? It's binding on.
I would have to start saying, well, I think I must be right. If I cannot distinguish Google and Robertson at all, then no, I think I'd have to then fall back on.
From my own part, I'm very sympathetic to your position, having an authority produced only the day before. But if it's binding on us, and that's the end of it.
What I want to do is simply to look at Robertson and Google, and to see if on the facts which element of the case it falls into. Because
when you say that is presupposing that there is a difference between late service on the one hand and wrong method on the other.
yes,
Because if you're wrong about that, there isn't that the point goes anyway, doesn't it?
if there's no difference, then the point goes away anyway. If it's a distinction without a difference, the point goes away. But that comes back to essentially my submissions on the appeal. And I think the first point my Lord asked me to deal with was, can I get away from Google and Robertson at all? Because if I cannot show that, then I'm in far more difficulty. So I agree, of course, that it was the paragraph 5 of the judgment confirms it was the claimant's application for relief from sanctions, which comes at the same time as the relevant form is filed. So that coincidence of timing, I would suggest, is going to be very, very important. We go on to rule or paragraph 10 and 6.34, and this is a point, of course, I'm talking to lordships, where the claimant intends to have a claim form of defendant to rule 632 or 633, the claimant must A, file with the claim form a notice, and B, serve a notice with the claim form. And 2, where the claimant fails to file the claim form a copy of the notice, the claim form may only be served once the claimant files the notice or if the court gives permission. And we're going to look at the part of the judgment where it's confirmed that permission cannot be given retrospectively. Permission is prospective for the purpose of 6342. And as you pass through the judgment at paragraph 15, I would agree, and I'll come on my submissions on the main appeal, the distinction between procedural rules and duties on the one hand and provisions in part 6 on the other. And what I intend to do is to look at what actually part says 6 about deemed service, which the Master picked up on.
What's that got to do with whether the defendants in this case were obliged to provide an acknowledgement of service and obliged to make an application under Part 11? That's all we're concerned with, because if the Master was wrong about that, that's the end of this.
Yes. I would suggest the key passage, which I would place the most weight on, are going to be paragraphs 18 and 24. That will be, and I'll develop that. Paragraph 18 is first instance decision. Because of the failure to file, serve, N510, the claim form we received but had not been served, it was clear the claim form could only be served once form N510 had been filed, or if the court had given permission. No appeal against that finding. In paragraph 24, precise nature of Robertson's default, remedy available to cure it. There be no valid service of the claim form on 5th of April 2022. Property concedes the service of 5th of April 2022 without form N510 meant the claim form not being properly or effectively served.
The conventional position where a claim form cannot be or is not properly served within the specified period is for the claimant to seek an extension of time for service.
But this is the point. If you haven't filed an N510, that is the end of it. You cannot even seek an extension of time. You cannot, unless you get the court's permission. The only way you can
seek an extension of time, but they accepted they weren't entitled to an extension of time. They couldn't trigger the rule, just as the court found you couldn't trigger the rule because it's a stricter rule than simply relief from sanctions.
But if you don't file the N510, then you cannot carry out service. It's merely delivery, which I should be submitting is very different to what happens if you follow Part 6, you effect service and the deemed service provision in the rules, but you do so out of time. But the first point about Google and Robertson is that attempt at service on the 5th of April 2022 was not in a method permitted by the rules.
I mean, you say this is a wrong method case.
Yes.
Yeah, fine. Yeah.
And indeed, I take that submission from paragraph 32. The claim form can only be served once the notice has been filed or if the court gives permission for service.
Is that method or is it a condition? It's a condition precedent to valid service, isn't it? Rather
Yes.
than a methodology. It's not the means by which it's served, it's the fact that it can't actually be validly served unless you take certain steps first.
Absolutely. It is a condition precedent,
Yeah.
being able to serve a claim form. You cannot even take a service step.
At the moment, what I'm struggling with is why there is a distinction between not being able to serve validly because you haven't carried out procedural steps that are required of you first, and not being able to serve validly because you're out of time for service.
And this is where I want, in due course, to develop my submissions on Part 6 and where the authorities do appear to find a difference, although I have to concede, as the Master himself found, there are no direct authorities on this point.
So one has to fall back on a conceptual reason why there should be such a distinction.
Yes, and I should be submitting there is a conceptual difference between a method that is valid and permitted within Part 6, albeit out of time, and a method which is simply wholly wrong.
Both lead to questions of jurisdiction.
Yes.
That's the problem.
Both lead to the same issue, namely, does the court have jurisdiction over the defendant? If service has not been properly effected, on the face of it, the court doesn't have jurisdiction over the defendant.
On the face of it, yes. But the question then comes, what should the defendant do? And this is one.
Why should a defendant do anything if it's not the subject of the jurisdiction of the court? I mean, let's strip everything aside here. On the face of it, the claimant mucked this up, and they failed to serve in time, and they didn't get an extension of time. The defendant at no stage acceded to the jurisdiction of the court. How then do we end up in a position where we pretend that the claimant's default didn't happen because of an alleged omission on the part of the defendant. That's really what the second part of Google and Robertson was all about.
Well, the master, and I say the master was correct, was to draw a distinction between what you need to do in Part 6 and what you need to do in Rule 7.5. And Part 6 is to do with validity of the method, and Rule 7.5 is a time in which to do it. If I can take...
So if the master's, as the point I put to you before, if the master's differentiation is wrong, that's the end of the point.
Yes, but then I will be coming on to, in part of the main appeal, to say there are a number of reasons why, policy reasons as well, as why the master's distinction is right and conceptually right. But the starting point, I would submit, is going to be the CPR and the distinction drawn in the CPR between Part 6 and Part 7. And the master, and if necessary I could take you to that part of the judgment, relies upon the linguistic difference as he styles it, but it's Rule 614. Seems to be the core or the nub of this. And rules, it should be in the authorities bundle if I get it assists.
Yeah.
And it's behind tab 22 and page 494 in the authorities bundle.
614.
Yes, deemed service.
Yes.
Claim form served within the United Kingdom in accordance with this part is deemed to be served on the second business day after completion of a relevant step under Rule 7.5. So deemed to be served, if you take the step, it is served. And then, as we've just been seen, 7.5 tells you the time limit within which the claimant has to carry out the step. And this...
So you're not saying that it's deemed to be served even if the step is taken out of time?
Well, the rule doesn't say anything about when the step is taken. It's...
No, but 7.5 does.
Yes. And
it's quite clear from 7.5, if you haven't done it within the time stipulated, then you haven't served. So then 6.14 wouldn't deem service.
But 6.14 only refers to completion of the relevant step. It doesn't say you must do it within the time limit within 7.5. It only talks about completion of the relevant step.
So you're pretending, even if you've not complied with the rules, that you have. Or the defendant has to pretend that, does he? Is that how this works?
Yes.
People criticise the rules. I know this, having been the chair of the Rules Committee for a decade and having been the editor of the White Book. People criticise the rules for being complicated. We try so hard to make it simple. We try so hard to ensure if you do this, then that follows. Google and Robertson was the first time I came across an argument that said that, well, it doesn't matter what actually happened, you have to pretend it was in accordance with the rules. And that's what you're suggesting. And I just don't see how that can be right. I think I said in Google and Robertson, it would make the rules 5 times as long because we'd have to deal with every single possible default and what the consequences were. So deemed service, it's a claim form served is deemed to be served on the second business day after completion of the relevant step under Rule 7.5. If you haven't taken the relevant step under Rule 7.5, 614 can't apply.
I was just, all you need to do is actually carry out a relevant step and then it's deemed served. That was...
Yeah, as long as you do it in time. That's the point. You can't be carrying out a relevant step unless you do it within the time for service. Then obviously 614 will have effect for calculating the period of time for acknowledgement of service and so on and so forth.
Well, it's embodied in 7.51.
Yeah.
Before midnight, 12 midnight, on the calendar day, 4 months after the date of issue of the claim form. It's an integral part of 7.51. So the steps required are those taken before that time.
So you complete the step under 7.51 within the time so stipulated, and then there's a deeming provision that kicks in.
But you could easily have said after compliance with 7.51. It simply refers to the very...
That's effectively what it says. After completion of the relevant step under Rule 7.51. If that's not compliance, I don't know what is.
If you do something after midnight on that time, you haven't taken a step under 7.51, have you? Because you
may have taken a step that is referred to in Rule 7.51, but it's not a step under that rule.
I would submit you have completed the relevant step, and I would suggest that the rules are structured in a way that flows from this.
What it means is effectively you're saying there is deemed service, but it's out of time.
Yes.
But that's absolutely, that drives the coach and horses through the whole concept, because that means that the whole deeming as to when you're served based upon when you've completed the step becomes complete nonsense.
Well, it also means that you can ignore time limits with impunity, because why does it matter? You could serve at any time. You get your claim form out and then you serve it 6 months after the time, and it's deemed to be served under 6.5 because you've left it with a courier. Bad luck to the defendant. The defendant's actually got to come back and make a fuss about it.
So deemed served obviously means validly served.
Yes.
But then you'd be saying, if you follow Part 6, it is deemed to have been served in accordance with Part 6. It becomes almost quite circular. And in respect of the point of the defendant's own position, I would submit that yes, the cases do support the proposition. But once you have property served in accordance with Part 6, the defendant has been served properly in accordance with Part 6, they do come under the jurisdiction of the court.
Correct, but that begs the question of what's meant by the words after completion of the relevant step under Rule 7.5. And it seems to me that, especially when you actually look at the relevant commentary, making the explaining why the changes were made to the rules, which I think was actually quoted by the Master in one of the judgments, the whole policy objective was to stop what had happened before, which is that the deemed service rules were artificially creating a situation where somebody was deemed to be out of time for service. And so the whole objective of it was to say, right, well, you're in time for service if you complete the steps that are designated under 7.5, but from the perspective of the defendant, time starts to kick in when you're deemed to have completed the service, and therefore you then have the relevant time period for acknowledgement of service running from that date, which on the face of it seems to me to make complete sense, but you've got to do 7.51 first. If you don't, then that rule doesn't kick in at all.
Because the difficulty which was encountered in Coro was, if that is correct, then you are effectively asking the court to make an order of its own volition. The claimant has brought it before the court, in many of the cases, for an application for extension of time. But you're then asking the court to make an order of its own volition in effect of that.
Corot is a very different case, isn't it? Because Corot, this case, like Robertson, was a case in which the court considered service. And the court concluded that service was not properly effected. It wasn't served in time, and there was no entitlement to an extension. That's what, and that's what happened in Google. That's what happened here. So it's not then a question of the court making orders of its own volition. The court has considered service, and we know that service means jurisdiction, see Hodinot. So the court had therefore considered that question and had said, no, this was not properly served.
Now, I would suggest, if we turn to Corot, because it is one of, I would suggest that what I need to do is reconcile Corot with Google and Robertson, or at least it does, at first blush, need to be reconciled one against the other. Tab 19 in the authorities bundle, the second tab, and I accept it is difficult to ascertain precisely what the situation was in Corot because of the procedural twists and turns that case had taken. And I can illustrate that quite briefly by going through that authority. First of all, the point about service, paragraph 10, that's page 454 in your authorities bundle. And it says, it is now apparent that GL... Sorry. The paragraph, the top of page 454, we have name and address given, Crown Prosecution Service, correct name of defendant, came from the explained reference to government legal department in the box, that had malign consequences. Paragraphs 9 and 10 was the effect of that. So this appears then to be a case where there are concerns about service, whether it's going to be completely wrong method or just or so forth. The next point in Corot is that there was no acknowledgement of service. Then at paragraph 46, we have the hearing for Her Honour Judge Boucher in central London. And that is going to be criticised because they hadn't filed an lodgement service, hadn't made an application under Part 11. But this hearing, and I can see my law's point, does not come about because the claimant is criticising or seeking to validate its service. This hearing comes about for quite some different reason. But certainly, that is the key point. Then we go on to
the hearing before Judge Boucher on whatever the date was. What were the applications that she was considering?
To find out paragraph 40, it was the application for an oral hearing. Because
I mean, it was a procedural dog's breakfast.
Yes.
Case. And Yes. Okay. So there was a hearing before Judge Boucher. So 40 and then 46. Not happy reading. Yeah.
Then I go on to paragraph 64, which is headed relevant principles.
Yeah.
And the first point I'd highlight was it was wrong of Miss Longston Smith and wrong of Judge Boucher to accept that effective service means proceedings do not exist. Proceedings have been properly issued or properly constituted where not have been properly served. And I'll be flagging a point about the limbo point that's been made in the appeal.
The limbo point what?
Whether one's point is, I think it's made in either ground 1 or ground 2, is if the court should not have taken any further steps because the proceedings end up in some kind of limbo.
Well,
because they haven't been properly served, there haven't been, service has not been cured.
No. So the 64 is not an issue in this case. Everybody accepts the proceedings continue. The question is whether the defendant are the subject of the proceedings.
Defendant paragraph 65, procedure for disputing the court's jurisdiction stay down in part 11.
Yeah.
Paragraph 66, and we've been discussing this, a reference to the court's power or authority to try the claim.
Yeah.
Paragraph 68, given the breadth of the terms of House 11, the absence of an alternative route elsewhere than CPR, CPS could adopt it, did adopt, we're told that CPR Part 11 provides the procedure of disputing the court's jurisdiction in a case such as this.
Or completely unexceptionable. In a procedural dog's breakfast, in a case where it's unclear what the status of the claim form was, and a myriad other points, the court was quite right to say, well, if you're taking a point about jurisdiction, then you need to raise this by way of your acknowledgement of service, or do not, and a Part 11 application. But what would have possibly been the purpose of that here in circumstances where, as I put to you already, on the claimant's own applications, service and jurisdiction were an issue?
And that, I would suggest, creates a distinction as to when Part 11 is mandated.
No, but what's the answer to that question? What possible purpose could... One can see the purpose of an acknowledgement of service and a Part 11 application in this case, written right across its forehead. But in our case, as in Google and Robertson, what would have been the purpose of a separate Part 11 application or an acknowledgement of service which says jurisdiction is an issue in circumstances where the claimants knew that because the claimants were desperately trying to validate their service?
Because it brings out any points the defendant wishes to make about jurisdiction in a way that's properly regulated by Part 11 of the CPR.
That's just, with respect, just pointless verbiage. What else was there? If you hadn't served, and if that was not extended, then the defendant wasn't the subject of the court's jurisdiction in these proceedings.
Well, there would have been, could not have gone on, realistically.
Against the defendant?
Yes.
Yeah. And just remind me, there were two defendants?
There were, yes.
What's happened to the second defendant?
That was settled.
Right, fine, okay.
There was a separate consent order entered into between the first judgment and the second.
That's very helpful. All right, so I mean that point is in Google because I think somewhere I say, yes, 72. There was no requirement for Google to make an application under Rule 11. Such an application is required in circumstances where a defendant decides at the outset that he wishes to make a challenge to the court's jurisdiction. If so, he's required to communicate that position to the claimant, hence the importance of an application under Rule 11. You could say that's a paraphrase of Lord Justice Stuart Smith in Corot.
Yes.
But in the particular circumstances of this case, that was unnecessary. Here, Google were responding to Mr. Robertson's own application to rectify his invalid service. Google made it plain from the outset they opposed that application. They are, of course, quite entitled to do so. It would have been apparent to everyone that if Mr. Robertson's application failed, the claim form was not validly served. These proceedings would be a nullity and the court would have no jurisdiction. Accordingly, there was no need for a separate Section 11, a Rule 11 application. That would have simply duplicated time, paper and costs. And that's ultimately what I'm interested in. Isn't that right? In this case, exactly the same.
I would point to what was actually said in Hodenow, but also look to the facts of NHS and Battaglia, and to say that actually the rules have been interpreted to say, even if it is considered being duplication, it is appropriate to make a Part 11 application in those circumstances.
But in Hodenow, there was an acknowledgement of service because it had been validly served, so there was an acknowledgement of service and they ticked the wrong box.
Yes.
So absolutely not this case. And in Battaglia, something similar had happened, but the court were prepared to allow a Rule 11 application because it was clear that jurisdiction was in issue.
So,
I mean, we come back to the point that we asked you originally. How can you avoid the consequences of Google and Robertson? Because Google and Robertson explains how Hodenow and Battaglia are different sorts of cases.
Hodenow was, the strict ratio of Hodenow was, it was for statutory waiver, it's Rule 11.5. If you file an acknowledgement of service, but you don't make the application, then you are,
you're deemed to have accepted the court's jurisdiction.
Yes. But that point as to whether or not it's duplicitous or repetitious, that is actually dealt with as part of the discussion in Hodenow. And if I might take the court to Hodenow, where that's dealt with, that's in your authorities bundle, tab 3. It's paragraphs 25 and 26. And I'm not trying to retreat from the point about the statutory waiver in Hodenow. It was a different case because of that acknowledgement of service.
So which paragraph of Hodenow?
That's paragraphs 25 and 26. Page 52 in your authority.
Yeah, which particular, what is the point?
The question is whether or not it's duplicitous or repetitious, as in the words of the first instance judge, to insist on the defendant making an application. Now, in this case, of course, there were...
This wasn't a case where the claimant had been told your claim is out of time. Your claim form was served out of time. This was a case in which the claim form, when it was served, was considered valid, and they put in an acknowledgement of service.
Well, it came before the court because the application to extend time for service had been granted, but then the defendant applied to set aside the order for the extension of time. And then we end up in the same position.
No, it's not the same position. That's again what I explained in Google and Robertson. Here, when the claim form was served, the defendant treated it as valid and put in an acknowledgement of service. And they didn't tick the jurisdiction box, saying that that was an issue. So that is quite properly deemed to be an acceptance of the court's jurisdiction. So my point about the duplicitous nature of a Part 11 claim doesn't arise, because it's duplicitous in circumstances if the claimant has raised it. And I'm still waiting to know why it is that a claimant who has failed to comply with the rules is entitled to have that default ignored.
The other case was I referred to as Battaglia
Yes.
and NHS England, because that was on the claimant's application, as I recall.
Yes, that's the one where I think Lord Justice Bean says, whatever one thinks of Hoddinott.
Yes. ... Indeed.
But he, which tab is it?
It's tab 18.
Tab 18. He also summarises, in my judgment, rightly, the ratio of Hoddinott, the limited tab.
It's tab 18 in the authorities bundle, so I think it's the second.
Tab 18, yeah. He says, Hoddinott lays down that if a defendant acknowledges service without making an application under Rule 11 for an order declaring the court has no jurisdiction to try the case, that is taken to be acceptance of jurisdiction. So it's an acknowledgement of service case, which neither Google and Robinson nor this case is.
The point in Battaglia, and I can go back to Lord Justice Bean's summation of the issue at page 438 in the bundle, paragraph 1. Defendant acknowledges the service, applies to challenge jurisdiction, fails to do so expressly under Part 11. The other point about Battaglia was the claimant's application for relief. That's at paragraph 8. And then at paragraph 9, we see the acknowledgement of service. In paragraph 10, we have the application for strikeout.
Yeah.
So, the issue is, if
the defendants were successful on appeal.
Because they were successful on the basis that it isn't the ticking of the box, which is the requisite, it's actually the making of the application. And they could validate the application to strike out as in a Part 11 application.
Yeah, so the fact that they too had served an acknowledgement of service and got that wrong, unlike Hoddinott, was not, in the circumstances of the case, was not held to be deemed acceptance of jurisdiction.
Yes.
But they were both acknowledgement of service cases.
Yes. But Lord Justice Bean placed weight, I would submit, on the distinction between making an application containing an error and failing to make a necessary application at all. That's in paragraph 32, Roman 3, which is at page 448 in the bundle.
Yeah.
And then at 35, the critical question is whether the defendant's application can be treated as having been made under Rule 11. So, paragraph 34 says, put to one side whether or not the box had been ticked. The critical question is, have you made the application? That's what paragraph 35 says. So the key point in Battaglia and NHS wasn't to say there's no need at all to follow a Part 11 procedure. It was to say, can we validate what the defendants did as being under Part 11? And I say that is where this case is really quite different. The incident case is really quite different because in Battaglia, the claimants had also applied for various relief. And it could be said that the defendant shouldn't have done anything at all, should have filed no acknowledgement of service, and there would be no procedure under the CPR to actually contest what happens next.
They didn't need to contest what happened next because you'd lost. What? Let's go to the counterfactual. You've lost. There's no, the claim form was not served in time and you're not entitled to an extension of time. Then what?
If a
that you say there should then have been a Part 11 application.
Yes.
But for what purpose?
So all the jurisdictional challenges, I mean, orders...
There was no jurisdictional challenge beyond the fact that you hadn't served the claim form in time.
But all the orders that the parties want the court to make...
The defendant wasn't subject to the jurisdiction, so why did it need to require the court to make any orders?
Let me ask you this. Could you have got judgment in default of acknowledgement of service?
Yeah, that's fine.
That, I believe that part of the default judgment rules has been... Because there will be no acknowledgement of service on the file, which is what you have to check. Is there acknowledgement of service or is it defence at the time the order is sealed?
But they're not obliged to acknowledge service because you haven't served them properly.
No. So...
And Shibboleth, which was dealing with default judgment in those circumstances, says such a result would be bizarre.
We can turn up Shibboleth because that is one of the cases which I suggest is relevant, is what is said in Shibboleth about the acknowledgement of service point.
It's tab 2, isn't it?
Yes, I believe so. And it's paragraph 20, so it's page 20 in the authorities bundle.
Yeah.
And the proposition advanced on behalf of the claimant, omission to file and prescribed time with acknowledgement of service and no effective service ever being accomplished can be a basis for obtaining judgment in default acknowledgement of service strikes one at the first flush as bizarre. Giving a judgment for lack of acknowledgement procedural steps being taken, which has in truth never or never effectively been taken, would not appeal to many as a logical, indeed a fair feature of a system of civil procedure. Ben goes on to discuss the 12.3 procedure.
Yeah.
I then go on to look at the last part, which starts, the procedure for acknowledgement of service is thus workable only if a date of service can be identified. Accordingly, if there were complete absence of service, there would be no way of identifying whether 12.3 had been complied with, which I would suggest gives me some weight to my distinction which I draw between Part 6 and Part 7, because if I serve in a method permitted by the rules under Part 6, I do get a date for service, whereas...
It's not valid service, and paragraph 23 says in the absence of proof of valid service, the claimant's not entitled to judgment in default.
But I do get a date when I can produce the acknowledgement of service.
No.
I believe this point was discussed in, when I looked at part of the transcript for Google case, was the case of someone's tried to serve you by leaving it in the neighbour's garden. The neighbour gives you the letter, but you don't open it. Has there been valid service? I'd say no. not at all, because it's not been serviced in accordance with Part 6. That is quite different to a scenario where Part 6 has been followed, such as by posting a deemed date of service for that, and it arrives with a defendant, albeit a day late. Then I would say that the procedure in Parts 9, 10 and 11 is engaged once the particulars of the claim thereafter are served. And you do go down this route. It does provide a passage. There is a conceptual difference.
But if you're right, and come back to this point, if you're right, you could sit on your hands and serve it the day or 3 days or 3 weeks after the date for service, and the defendant would be forced to engage with the litigation in circumstances where there's no jurisdiction over him.
I would say that is correct, and I would say that is the consequence of the rules. And I don't, if it needs to, we can turn it up, but remember the facts of Wright Hassel against Barton, where the claim form was purportedly served by email, and the solicitors refused to file an acknowledgement of service, said you haven't served according to the rules. And I'll say it's absolutely the right outcome and approach under the civil procedure rules.
I can see disaster coming. Clever lawyers would say, you acknowledge service. That's an acceptance of jurisdiction. The rules would be expanded enormously to suggest when and where acknowledgement of service didn't have that consequence or this consequence. The rules have to proceed on the basis that parties are complying with them.
Yeah, I can see a principled basis for a distinction to be drawn between situation A, which is the Corrie type situation, where service is invalidly affected within time, and then it's open to the defendant to either waive the irregularity or to contest the jurisdiction. That's Corrie. And a situation where there is no valid service within time, and therefore there's no jurisdiction because the claim form is basically just not granting jurisdiction over the defendant, where the defendant really shouldn't be made to do anything because they're not subject to the jurisdiction of the court. I think time does make a difference. But at the moment, I'm finding it very difficult to see that there is a principal distinction between using an appropriate service method and using an invalid service method for these purposes.
The conceptual difference I'd submit is when you follow Part 6, that is a method that the rules permit for serving a document. And it is therefore deemed, if you follow that method, that that document has been served. We leave aside the time. If you follow what you're supposed to do under Part 6, you have done what the rules require of you. So, if you have a claim form that's been served a week late, then the rules, pursuant to the rules, it has come to the attention of the defendant, it has been validly, has been served on the defendant. And that conceptually is different to a scenario where you are outside Part 6, such as if you send an email or if you use another method which is not currently permitted by the rules. Conceptually, you are not using a method which is permitted by the rules to bring the defendant's attention to the service of proceedings.
But the other non-permitted method may equally bring it to the attention of the defendant. The defendant may be jolly well aware that you want to bring proceedings against him. Either way, even if the neighbour hands over something that's left in the neighbour's garden.
But there needs to be a bright line distinction between a service method which is valid and a service method which is invalid. And this is where I think my learned friend and I are on all fours. Is that there is a bright line distinction between bringing the defendant's attention to the fact the proceedings being instituted against them and the method, the formal method upon which they are served. The rules need to have a formal method upon which it's accepted that valid service has taken place for the start of a timetable under Part 9. And I was going to say Part 9, 10, 11, or possibly also the rules for defence as well. And you can take that from valid service. You don't take that if it has been carried out in a method that's impermissible under the rules.
And you don't take that if it's late. We know that because here your solicitors quite rightly made an application within a week seeking a declaration that they'd served validly and or seeking an extension of time. So they had failed to serve in time and they were aware that they then needed the court's assistance.
Yeah, yes.
Exactly the same as if they had used the wrong method. Anyway, all right. So where are we? We've looked at Hoddenot and Patalia. We looked earlier at Coro. What else is there in relation to how and why you say that the ruling, effectively the result in Robertson and Google, doesn't mean that the appeal in this case should be successful?
I think it would be appropriate for me to take you to the Dubai Financial Group case, because that's the other Court of Appeal decision, which also deals...
I understand, though, what you're doing here, because it seems to me that you can look at these authorities, but they were all considered in Google and Robertson. But at the end of the day, the point on the appeal is directly the one that was decided in Google and Robertson. So are you saying that Google and Robertson was per incuriam? Are you saying it's wrong?
No, I'm not saying it's per incuriam. I'm not saying it's wrong. I'm saying it's a different category of case.
So this is just simply the category 2 and category 3 point.
Yes.
That's the only point here.
Yes.
Between the two. And you say that Google and Robertson was directed only at category 2 cases.
Yes. Because service could not have taken place. It was a condition precedent service to have that form N510.
Despite the fact that that doesn't appear to be in any way part of the reasoning of the court.
I would say it is part of the reasoning of the court. But the reference in the Google case to the need for the N510, the mandatory requirement for it for valid service, I would say that once you've made that determination, to go on from there to then say, and because of that is out of time, is strictly obiter, because you don't need to go on to make on that finding, and therefore any service is out of time, because once you found that on the 5th of April...
No, but the point is you're saying that there is a distinction between invalidity due to using the wrong method and invalidity because it's out of time.
Yes.
But that is not a distinction which, as far as I can see, in any way finds its way into the reasoning of the Court of Appeal in Google.
But it is a distinction on the facts, and the court was not presented
69, sorry, forgive me, 69 is a defendant faced with what it considers to be defective service and an application by the claimant to rectify that situation, obliged either to serve an AOS or to make an application under Rule 11. In my view, the answer to both questions is no. I do not see how you can read that as referring to defective by reason of method, but not defective by reason of timing.
I would submit that there is a distinction between permitted method within the meaning of Part 6 and time for service within the meaning of Rule 7.5.
But forgive me, but what you have to establish is that that was a distinction which can be drawn in relation to the Google decision. Because unless the Google decision is clearly on point, unless it is only directed at method. And that is not the way it is expressed, it seems to me.
Well, this depends on how, well, first of all, the facts of Google, as my prime submission has been, it was condition precedent to file form, it wasn't, therefore, invalid service. Number two is about the rules and whether or not, paragraph 71 of Google, whether they're obliged to serve an acknowledgement of service in the present case. I would submit that, in fact, my interpretation of the rules, as indeed the Master's interpretation of the rules, was different. When you look at 9, 10 and 11, they don't draw a distinction between valid, well, they don't, I would submit, it doesn't refer to timing at all. It just simply refers to the facts of service. And I take my Lord's point.
What, 9, 10 and 11 of the rules?
Yes.
No, they assume valid service.
I think I take my Lord's point.
I mean, that's the point. You can't have rules relating to acknowledgement of service and the rights and obligations on the part of a defendant if the step that would involve the defendant at all hasn't been properly taken.
What's the first sentence of paragraph 70 of this judgment?
Well, this is my Lord's point. The rules build upon the rules. Otherwise, one has
Otherwise, the white book would be 10 volumes. And I don't know. Perhaps that's what you all want.
Maybe Sweet and Maxwell would, but
I mean, it is. It's always a sadness when you know the rules are the subject of this sort of debate. Anyway, there it is. You say, as a matter of fact, there is this distinction, and you say that Google was dealing with Category 2, not Category 3, assuming that the court is, this court considers that there is a valid distinction between the two.
well, maybe if I can just take the court through the rules and to see how my submission plays out very briefly. Part 9, which isn't in our authorities bundle, but rule 9.1, subparagraph 2, where the defendant receives a claim form, not served, receives a claim form which states particulars of claim are to follow, he need not respond to the claim until particulars of claim have been served on him. And then at 9.2, the parts excerpted in Google, is when particulars of claim are served on the defendant may, when it goes through...
Because that's when the obligation to trigger the acknowledgement of services, that's where you find that obligation at 9.2.
I would then go on to part 10, which is, and in particular 10.3, and possibly this is where the important distinction lies. So 10.31a, the general rule is that the period of filing an acknowledgement of service is 14 days after service of particulars of claim, where the defendant is served with a claim form which states particulars of claim are to follow. So the Master first instance in my submission is, it's the service of claim form and particulars of claim, which then leads to the time period for filing the acknowledgement of service.
The valid service, the proper service. That's the point. That's the building on point.
Yes. And I would submit that what you see, everything being consistent with that, the question hasn't been resolved until now, is a question of the time.
Can I just ask this? We know that a defendant can serve an acknowledgement of service and can dispute the court's jurisdiction in that. There's a box and so on. In the present case, if before the first hearing before the Master, the defendants had filed an acknowledgement of service, ticked the box and said, well, service was invalid and therefore there's no jurisdiction, which is obviously what they were arguing before the Master. But assuming they'd served an acknowledgement of service and ticked the box, even on your case, they wouldn't have had to do anything else.
No.
So this does come down to a entirely procedural, on your case, omission.
On the facts of this case, yes. Although I think in my skeleton argument, I have referred to 2 cases, at least, where it would make a difference in a matter of policy. And that was, one of them was Mansard, where 3 of the defendants filed an acknowledgement of service late, the day before the hearing, intending to contest jurisdiction. And there the judge found, because they were out of time, therefore it would have turned back, they couldn't contest jurisdiction anymore because they were simply out of time following the acknowledgement of service. So.
Fine. But that, again, is where it's the defendant raising jurisdiction for the first time. Not this case, because the claimants, a week after they had served invalidly the claim form, they had raised the jurisdiction point in their own applications to the court.
But the point
so there's not a policy. The policy must be to keep things as simple as possible.
And again, I'll draw upon that case in Coro, which is to say that in Coro, the hearing was derailed by this point, and then in Mansard it wasn't.
No, Coro clearly it was, and hence the need in Coro for a Part 11 application. I get that completely. But, and as I say, I acknowledge that, why that's important in my judgment in Robertson, in the bit that I read out before. Because it is very important that if there's any doubt about it, if there's any doubt that jurisdiction points are in play, a defendant must do that. The question is, here there was no doubt, so as you accept, all we were missing on your case was an acknowledgement of service with the right box ticked.
So that would effectively be a rule, but if the jurisdictional point is raised by the claimant themselves, there's no need for the defendant to make any application themselves. They can simply respond to the claimant's application. But if there is no jurisdictional issue in play before the court yet, as you see in Coro, as you see in Mansard, then the defendant needs to raise the jurisdictional issue, and the only way to do that, as we see in Hodnott, Mansard, etc., is through a Part 11 application.
Yeah.
But I would submit that that may well be a clear and good rule, but it's not a rule that I find in the civil procedure rules, which gives the only outlet for that jurisdictional challenge as being the Part 11 application.
Yes, if there's an acknowledgement of service, which goes to the debate we've had.
Yes.
Yeah.
So I would, to make this point briefly, accept, and I would submit there is a need for there to be a pressure passage through which jurisdictional challenges are channeled. It may well be preferable, but Part 11 says if this point has been raised, you don't need to do it. But that isn't what Part 11 says. But it is Part 11 which creates the only procedure for raising these jurisdictional challenges.
Yes. Well, Yes, in the absence of any other method by getting the jurisdictional dispute before the court.
But if one leaves to one side all the cases, and one was to look at the rules simply and say, how do you get a defendant's jurisdictional challenge before the court?
There are thousands of ways. Thousands of ways. Because a claimant often raises jurisdictional points in its own applications, as happened here. Your solicitor looks puzzled. Let me explain. When a claimant seeks the court's assistance because the claimant has failed to comply with a rule of service, service is concerned with jurisdiction, see Hoddenot. Therefore, the claimant is invoking the court's assistance in relation to a jurisdictional dispute, because if service is not extended, the time for service is not extended in circumstances where the time limit's not been met, then there is a jurisdictional problem. The defendant isn't required to do anything in those circumstances. It would be bizarre. So that's where we come back to, I think. Yes. Anyway, that's what you say the consequences are in relation to Part 11.
Yes.
Yeah. No. Well, we understand that. You dealt with Coro. You dealt with these other authorities. Is there anything else on Robertson and Google?
No, my lord. I believe I've dealt with the substantive points that I was going to make as well in respect of the appeal, because by effectively Google and Robertson is the point that raises the other points I was making my skeleton island I've made orally.
Yes. Which
are the linguistic structure of the rules as determined by the master.
Yeah.
The difference in the rules between service that's valid and service which is utterly invalid. The policy reasons why it should be brought before the court, and why the CPR Part 11 is the only procedure which identified for bringing it before the court and is adopted in the other cases. Possibly I might turn my back to see if there's any points.
No, please do. Could you just see what the position is in relation to filing? I'm assuming that didn't happen, but...
The claim form definitely was not filed on the 21st of April 2023. It would have been filed for issue, and the particulars of claim, as we know from rest of the judgment, were not written at that point yet, and they were filed and served a few weeks later. 3 weeks later? I think it's a few, but I think that's it. Maybe 3. That's it.
So yes, that's a good point of clarification. So the documents that were being the subject of the faxing, and then the documents left in the specific bit of the receptionist's domain, was the claim form.
I believe we set out in the supplementary bundle in one of the covering letters what was actually in these.
Because it wasn't the particulars of claim, so
no.
It was the claim form. What else was? Well, don't worry too much, Mr. Sortel. The position is that it was definitely the claim form.
Yes.
And the particulars of claim were...
They came later.
Came later, about 3 weeks later.
I would have to check, because I think it's dealt with in the Master's second judgment as to when, because we separately applied for relief, and that relief was granted in respect of the particulars of claim. But we can see from Supplementary Bundle, page 98, that what was served on Gailing Legal was claim form, list of claimants, response pack / acknowledgement of service.
Right.
Not particulars of claim.
Fine. So would this be right? That was another failure to comply with the order.
Certainly the failure to file and serve.
No, the particulars of claim.
That was another failure, yes.
Yeah. Fine. Okay.
They followed, and relief from sanctions was granted by the Master in respect of the failure to serve particulars of claim in time.
Right.
That's dealt with in in the second judgment.
Well, perhaps
Yes.
Go on.
It starts at paragraph 38 onwards, and then that's the defendant's application for relief, and then the second judgment, paragraph 45 onwards. I think there's 2.5 weeks. They were served on the 10th of May 2023.
10th of May.
That's at page 166 in the core bundle. Take that from my submission. And then paragraph 51 of the Master's judgment, page 169. The delay was short, only 2.5 weeks.
So I'm a bit confused. 45 says the relief from sanctions regime doesn't apply. But then it appears that's what he did.
45 was in respect of
The claimant's application. Which must have been in relation to particulars of claim.
it was, yes.
Judge Bird decided the relief from sanctions which didn't apply, circulated that authority. Common ground, it didn't apply.
So it's whether the full rigour of Rule 3.9 should be applied. We see that at paragraph 46 of the Master's judgment.
All right. Okay. Right. Well, I think before we go on, we'll rise and consider where we are. All right. Thank you very much.
All right, able.
was thinking about.
Yeah. At least want to say hello. I was quite embarrassed.
Did he say he was advising to too?
No, I think they're probably just out in the corridor.
Just out in the corridor.
Just deciding whether to sort of. Well. Oh, are we? Better put my hat on.
Thank you very much. Mr. Callan, we don't need to hear from you. The position is this. We will dismiss the cross appeal and we will give our reasons later. As to the appeal, we acknowledge at once the difficult position that Mr. Sawtell was in, given that we were only able to provide him with the authority that was handed down yesterday, and he has done manfully in endeavouring to persuade us that a different result should obtain. But again, for the reasons that we will provide in writing, we are firmly of the view that the decision and reasoning in Robertson and Google applies equally to this appeal, and the consequences of that will be that the appeal will be allowed, and we will set aside the Master's orders. Now, although that's the result, and as I say, you will get the reasons in writing, the reasons in writing will be effectively draft judgments, so they must be treated in the same way. That's to say, we will send them to you as drafts so that you can comment on our typographical errors, spellings, and so on, but it's not an opportunity to re-argue the case. The draft judgment is protected by the embargo, so it is confidential, and you both are very well aware of the consequences of referring to the draft before the final version has been completed. My clerk, I think, has a list of those people who will receive the draft, and at the moment that the distribution list will therefore be limited to them. When we hand down the judgment, we would also like to make whatever the appropriate order is. You have now plenty of time between you to agree what the order should be, and we would hope to receive, along with the corrections to our drafts, we would hope to receive an agreed order between the parties. If there are any points on which you can't agree, the best thing to do is to identify those in red on the proposed draft order, and for both parties to provide very short submissions as to why you contend for the different versions of the red part of the order that you can't agree. And we would, as I say, hope then to have the agreed order at the same time as handing down judgment. We're very grateful to you both. Obviously, we have read all of the material, even though we have only heard from Mr. Sawtell this morning. And so we're very grateful to everybody for their preparation. As I say, you will get the written judgment in due course. And I think other than that, perhaps only remains for me to apologise to Mr. Sawtell again for the coincidence of timing that has not been kind to him, and we are very grateful.
Thank you.
Thank you very much.
All right, in favour.